Hello guys. So in order to help you with the company law, we are starting a series for company law and it is made for CA, CS and CMA aspirants, those who are preparing for May 23 and June 23 attempt. Now we look at the company law and the Companies Act 2013. Now, as the act is there, so it is passed in the parliament with the majority of Lok Sabha and Rajya Sabha, and after the assent of the president, it becomes an act. So the Companies Act 2013 is an act of Parliament of India, and Companies Act 2013 is divided into 29 chapters. Now it contains the 470 sections and has 7 schedules. Now let's begin with short title, extent and commencement. This act is known as the Companies Act 2013. It extends to the whole of India including the state of Jammu and Kashmir because as per Article 370 the J&K is now part of India, so the act extends to the whole of India. And let's see that the Companies Act 2013 is applicable to companies that are incorporated under this act or any previous Indian company law. Before the Companies Act 2013, there was Companies Act 1956 and various other laws were also there in relation to the companies. So any company which is incorporated under the Companies Act 2013 or any previous Indian company law, the Companies Act 2013 will be applicable to it. And it is applicable to various class of companies like the banking companies, the insurance companies, the electricity companies, the entities that are specified by central government. Any other company which is governed by special act are also covered under this, provided that any law made in these specified companies should not be inconsistent with the Companies Act 2013. Let's say there is a provision in Companies Act 2013 and there is also a provision in the banking company. So the regulator of banking companies is RBI. So in case the provisions made by the RBI are more stringent than the Companies Act 2013, then the banking companies will follow the provisions of RBI. However, if they are in consistency with the Companies Act 2013, then there is no problem. However, if the consistency is not there, then the specific regulators will prevail and the companies will follow the directions or the instructions given by those specific regulators, and Companies Act will not work over there. Now let's look at the meaning of company. Now the company is derived from the Latin word in which com means together and panis means bread, means having bread and butter together, accompanying over a dining table was considered as a part of company. Now as far as the corporate law is concerned, company is an artificial person having a separate legal entity, perpetual succession and common seal. The members may come and go, but the company goes on forever. As far as common seal is concerned, it is optional and the digital signature can work over there. So, company is a legal person started by law and comes to an end only by law. Means it does not take the birth as a natural person takes birth. It is created by law. It is created by the law over there and it comes to an only by law. So company means a company which is incorporated under this act or under any previous Indian company law as told earlier. Now as the big corporates, they need the funds from the public, they raise the funds from the public. Now the capital of the company, the funds which the company needs, the capital, it is divided into small proportions and each such unit is known as share. Let's take an example over there that share capital of the company is rupees 10 lakh. The face value of each share is rupees 10. Now we can say that the entire bunch of 10 lakh is divided into smaller amount of shares and the face value of each share is rupees 10. So when we divide 10 lakh with rupees 10, we get 1 lakh shares. So we can say that this 1 lakh is a total number of shares which the company will issue to the people because it has raised the amount from the public. Rupees 10 lakh it has raised from public in terms of shares by giving the shares. So the shares are now in the possession of the people, and those people are termed as the shareholders. So we can say that shareholders are the owners of the company, and there are two types of shareholders. Those are the equity shareholders as well as the preference shareholders. The equity shareholders are basically the owners of the company because they carry with them the voting rights. The preference shareholders do not carry the voting rights. They carry the preferential right in respect of the dividend as well as in case of winding up of the capital. Now let's see that who manages or controls the company. The company is managed by the people who possess the relevant skill and expertise in the legal field. It is true that when we are starting a company, we need those people who can take a good decision, who have the top abilities, who carry with them the requisite skills. So the shareholders are the owners of the company, but there are so many laymen. They do not possess the relevant knowledge, the relevant skill with them so that they can run the company. So in order to run the company, to manage the company, or we can say have a control over the affairs of the company, then it is important to take requisite decisions. ठीक है, as far as the business is concerned, the top management takes the decisions, and it includes the directors over there. So we can say who manages or controls the company. These are the directors, as per point number 3 over there, that such people are known as directors. They are accountable to shareholders. It is true that they are accountable to shareholders because shareholders are the owners. The shareholders have provided their hard earned money to the company. So it is very essential for the directors to be accountable to them so that these shareholders can know that whether the funds are being utilized effectively or not. For example, the company has taken the funds from the shareholders and whether by issuing a document, and this document is known as the prospectus. Now we can see that if the fund is raised, and let's say the directors want the funds of the company to be raised to be utilized for project A, but they are utilizing for project B, it means the funds are not being utilized for the purpose it is raised. So for each and everything, the directors of the company are accountable to these shareholders as well as to the stakeholders, because the stakeholders include the internal as well as the external stakeholders. So the directors of the company, when they are running the company, they are looking into the affairs of the company. So it becomes a prime responsibility for them to be accountable to the shareholders, to the stakeholders over there. And we can also make a conclusion over it that directors take around 90% of the decisions of the company, because when they're running the company, so they have to hold a meeting for the shareholders, which is known as the annual general meeting, and they have to be a little bit accountable to the shareholders to tell them that the company is working, or the strength of the company, the weakness of the company, or whether there is an appointment in relation to the directors concerned, everything which is going to happen in case of company. For example, if it wants to increase the authorized share capital, now authorized share capital is something which the company can issue, which the company has the maximum amount of capital which the company can issue in its lifetime. So if it wants to raise its increase authorized share capital, then also it requires a ordinary resolution, uh, as along with the board resolution. So all these things we'll be looking into it, but the basic thing is that who manages or controls the company, it is the directors. Now let's look at the types of companies. Means the company is an artificial person created by law having a separate legal entity, perpetual succession as well as a common seal. Now let's look at the type of companies in the corporate arena. The first comes out to be the private company, then it comes out to the public company, then the one person company, then the small company, then the section 8 company, the government company. Now private company is a company which uses which, as far as the basics are concerned, it uses the word private limited at the end of its name, and it prohibits the invitation to the public. Means private limited company can only issue cannot is prohibited to issue the securities to the public. It cannot raise the funds from the public and by issuing its shares. This is a restriction given in case of private company, but it can issue the non-convertible debentures in the securities market and can raise the funds required, but also through the private placement basis, which all these things we will be discussing in detail later on. So we can conclude over here that private company is a company which restricts the right to transfer its shares. Means as far as the share transferability is concerned, it restricts the right to transfer its shares. And the private company also does not allow the public to subscribe to its securities, which I already told that it cannot invite the public. It cannot raise the money from the public by issuing the shares. Okay. Now let's look at the public company. Now public company is an open company, we can say, which can easily invite funds from the public. And as far as the members are concerned, in case of private company, it limits the number of members to 200. But as far as the public company is concerned, which I said a few minutes ago, that it is one sort of an open company, so it can easily borrow funds from the public by using the word limited at the end of its name. It is open, it can issue the prospectus, and it can raise funds from the public. Now when the company is issuing its shares for the very first time and bringing the offer, it is termed as the initial public offer. But as far as the if it comes afterwards, means one first time it has raised funds from public in terms of IPO, and again it wants to come, then it can come with further on public offer or future public offer. Like we saw the IPO of Paytm, the Zomato, etc. Now one person company means where there is one member, one director. Okay, so the entire the management is in the hands of one person. So it is it and the thing is that as far as the Companies Act 1956 was concerned, the concept was of sole proprietorship. But as far as Companies Act 2013, it brought about a revolutionary change by converting the transformation of a sole proprietorship into the one person company. And now the a single person can open a company, and the concept is one person company, which holds a great applause for those people who do not want more persons in a company and want to run their company on their own, to start their business on their own. So one person company is a very effective and a very good method. Now let's talk about the small company. Now small company is a company which is a sort of a private company and has certain limitations as far as the paid up share capital and turnover is concerned. So if the company that fulfills those paid up capital as well as the turnover criteria, so we can say that that sort of a company is a small company. Section 8 company is basically that company which is a sort of a non-profit organization, ठीक है, and it has some educational or the charitable or the religious perspectives over there, and that work for the non-profitable purpose. Means the ultimate aim of this is not to earn profit, because any business which we work on, or as far as the commerce is concerned, then the business is open for the purpose of making profit. But when it comes on to some social service is involved, then a person can open a Section 8 company, and few persons can open Section 8 company and take the approval of the central government over there, so that these companies can run and can the structure is such an in such an organized way that the ultimate objective is social service and not to earn profit. Government company is a company in which at least 51% of the paid up share capital is held by central government or the state government, or partly by central as well as the state government. We will look in these definitions in detail later on. Now we look at some other types of companies which include the holding company. Now say we say that X Limited is a holding company and Y Limited is a subsidiary company. So we can say that when we talk about the X Limited is a holding company. Now how we can say that X Limited is a holding company? Because X Limited may hold majority of the shares or the voting right or the control in some other company. So when one company holds more than 50% of the shares or the voting rights or control in some other company, then the first mentioned company is known as the holding company, and the second company means the company in which the first company or the is holding the control or the voting right or the shares, the majority we have to see, so it becomes the holding company. Basically, holding company means a company which holds majority of the shares, voting rights of the control in the second company, which is known as the subsidiary company. Now, associate company. Now, associate company is that company which holds more than 20% of the share capital in the other company, but the control over there should not exceed 50%. Means where the control over the company is more than 20% but less than 50%. Such types of companies are the associate companies. And Nidhi company is a company in which there are members and the members provide the funds to the members itself. Means that in economics there's a concept of self-help groups. Now what are self-help groups? The self-help groups are those who take the funds, and whenever a person or the member in need wants the funds, he can take it from that company, from that particular group, and as a, in the form of loan, and he has to pay the interest. But the interest, if he would have taken it from somewhere else, it would be much costlier. So self-help group is help that person. All of them provide the funds to him in case of need, and at a very lesser rate. The interest goes on, and after that, uh, whenever the person returns the money along with the interest, so uh, the interest forms the part of income of the group. Similarly is the concept with the Nidhi company, which we'll be discussing along with the proper section, proper what is given as per the MCA, which is the Ministry of Corporate Affairs, and each and everything, the paid up capital or on what companies are covered under it. ठीक है, so we can see that holding company is a company which means that if X Limited is a holding company in Y, and Y in if XYZ is a company, and we can say that it has three subsidiary companies: A Limited, B Limited, and C Limited. So XYZ becomes a holding company. Now the hold over the three companies, the A Limited or the B Limited or C Limited, can be in the form of shares or voting right or control. सो जिस कंपनी के अंदर वो चीज़ होती है, वो कंट्रोल हो गया, वो वोटिंग राइट हो गया, या फिर वो नंबर ऑफ शेयर्स का मेजरमेंट हो गया, तो जिस कंपनी के अंदर हो रहा है उस कंपनी को बोलेंगे सब्सिडियरी कंपनी, और जो कंपनी कर रही है वो कंट्रोल, उसको कहेंगे हम लोग होल्डिंग कंपनी. So we will be looking at all these definitions in great detail. Till then, stay tuned with this company law series. So now we look at private company. So private company, first of all, before starting private company, we can look at that in case of company, there are two most essential documents. The first is the memorandum of association, which is the charter document or the principal document of the company. And the second is the articles of association. Now the articles of association are the rules and regulations of the company. So private company means a company जहाँ पर जो articles of association है, जो main rules and regulations है, these rules and regulations include the following: restricts the right to transfer its shares. Now there is a basic difference between the term restriction as well as prohibition. Restriction means partial prohibition, means if some conditions are fulfilled, then the transfer of shares can be allowed in this case. So it is a restriction. Now we say at public places it is written that smoking is prohibited, means it can lead to cancer. So there is a complete prohibition over it. So as far as the private company, the third point is concerned, that prohibits any invitation to the public to subscribe for securities of the company. Means in any case, the private company cannot issue the shares to the public and can raise the funds. It can only adopt private placement method. Now what is, and for that purpose only it is written that it limits the number of its members to 200, because as far as the private placement is concerned, in that case also the number of members comes out to 200. So we can say over there that private company can follow a route which is known as the private placement in order to uh, raise the funds. ठीक है, because if the private company is not an open company, private company uses the word private limited at the end of its name, and also the liability of the members is unlimited in case of private company, means they can sell their own assets, ठीक है, in case the debts of the companies are not repaid. But as far as public company is concerned, then the control is in such a way that the liability is limited. So this is also a difference in case of private company as well as a public company. And private company uses the words as private limited at the end of its name, which I've already told that private company uses the word private limited and public company will use the word limited at the end of its name. Now, as far as the members are concerned, private company can start with 2 members. Mean if there are 2 subscribers, then the private company can be started. But as far as the public company is concerned, at least 7 subscribers are required in order to form a public company. Now also, as far as we have looked at the who are the owners are the shareholders. So we have talked about the minimum number of subscribers. Now let's look at who manages or controls the company. We know it very well in our earlier slides that these are the directors. Now, as far as private company is concerned, at least 2 directors are required and at least 2 subscribers are required. And as far as public company is concerned, so I have already told that 7 subscribers are the minimum number of subscribers, and the directors should be at least 3. So in case of private company, 2 directors minimum. In case of public company, 3 directors minimum. In case of private company, 2 subscribers minimum. In case of public company, 7 subscribers minimum. Okay. And as far as the members are concerned, the total number of members should not exceed 200 in case of private company. And public company, we know that it is an open company which can easily raise the funds from the public. So in that case, the limit on the number of members is not there and it is unlimited. And as far as the minimum amount of capital which is required to start whether a private company, one person company, small company. So earlier in Companies Act 1956, there was a mandatory requirement that there should be certain amount of capital which the subscribers should invest in order to start a company. But as far as the Companies Act 2013, the Make in India initiative, we can say, or the Skill India, we can say, in order to encourage the entrepreneurs in our country. So there is no minimum capital requirement in case of private company, public company, one person company, small company. So we can say that it is basically the motto of company law is to facilitate the ease of doing business. Rest we will be discussing in our next class.